This is the state of Michigan versus Franklin Miller, 26-00632. Is Franklin Miller here?
Yeah, he's.
Oh, have you spoken to your attorney today? Did you speak to your attorney today?
No, I didn't see him.
We haven't seen Ms. Wanji all morning?
She was earlier.
Talk to him?
Sitting next to him. No, I didn't.
You didn't talk to her?
No.
But you're sitting next to you?
Yeah, I don't know. Yeah, I didn't talk to him. I didn't talk to him.
Oh, okay. We'll call your case when we find Ms. Wanji. State of Michigan versus Paula Thornton. Paula Thornton here?
But she's not. I think this is Miss Robinson's case, I believe.
Okay.
Understanding.
I have 25 dash, it's 03601 and 26-01138. You have intel on where she is?
I don't have an update on Miss Robinson, and she's not heard from Miss Thornton as well. I don't know.
Sure. Thank you. Okay, State of Michigan versus Charles Moore, 6-01964. Appearance, please.
Ross Marshmeter for the people.
Assistant Public Defender John Lee on behalf of Charles Moore, who's in the courtroom and standing to my right.
Mr. Moore had a preliminary examination today for police officer assault resistant trust. How will you proceed?
Your Honor, as people understand that both parties are going to be requesting adjournment in this matter. On the people's end, we had two officers who were sent subpoenas on this matter, and upon looking at my system, neither subpoena was open. I did learn that Andrew Armstrong apparently is on family medical leave. I think that the new father, which explains why his hasn't been open, Joseph Traverso, I did talk to him this morning, and he indicated he could be here in about 30 minutes if we were to run the prelim today. However, my understanding, speaking with Mr. Lee, is that the defendant would like an adjournment because he has not had much opportunity to speak with Mr. Lee and wants to discuss it more prior to going forward with it now. So that is our request, but of course we'll defer to the court.
It sounds like even if Traverso appeared, you have to continue anyways.
Well, I think it's
For
possible
Armstrong?
that we would be able to bind it over with
Oh,
him.
Okay, so
And
you
we could
want-
get him here if the court wants to proceed today.
Do you wanted some time to?
Yes,
Further
you know, of
counsel.
course, our first question was, do you have witnesses? And then our next question, our next thing was, well, unfortunately, we're not ready to proceed today because we've only had one face-to-face meeting.
Sounds good. It looks like we've already waived the timeline, so we don't have to address that. We'll reset it.
Yes,
September 17th at 9:30.
September 17th at 9:30.
that worked great, thank you.
Sure.
I was actually going to request 3 weeks, thinking, you know, that would be nice, and you gave us 4, so. it caught me
That's
off
the least we
guard.
got.
Thank you.
No problem. Any additional matters for the record?
Nothing for the people.
Thank you. You're all set.
So I was talking to Mr. Miller, he said he was standing for his wives.
She's AWOL.
I seen her sit there in jury boxes. Doesn't work. So I was
The fact that he said he was sitting next to her and she was talking is very interesting.
literally.
It's an interesting situation. I saw Mr. Carter. Oh, Mr. Pfeiffer, long time no see. You're getting exhibits. That's not a good sign.
It's a great sign that I'm getting remarked ahead of time. I know my presence is ominous.
Unlike me, Mr. Pfeiffer never talks longer than he needs to, so.
No, never.
Mr. Carter's face. Whose opinion was that? Okay.
I may or may not have have a direct quote from you in a transcript of me saying, Your Honor, I could speak for hours about what was said was just wrong. You go, I know you can, Mr. Pfeiffer, please don't.
Yeah,
What?
please. spare us.
Mr. Pfeiffer and I are both so concise.
Don't you bring me out, you.
He's in
I
the
own-
pod.
I own that.
I plead the Fifth Amendment.
Wonderful. I hear you're gonna fill in for Ms. Wanji.
Yes, Your Honor.
I appreciate it. State of Michigan versus Franklin Miller, 26-00632. Appearance, please.
Ross March, from people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Miller this morning, Your Honor, as well as standing in for Ms. Wanji.
Oh, I guess before I was concerned about why Ms. Wanji didn't speak to him, I probably should have opened the sentencing file. She didn't have anything to speak to him about, because you didn't show up. Why?
For the PSI?
Yeah, what else would I be talking about?
Oh, I don't know, I was just thinking about my father. The reason why my father was ill, you know, and I just a lot of things going on. It's in my mind on a date, and I would like to see if I can get a little bit more time so I can finish the PSI.
What is your father doing now?
He's better. He's turned 87 yesterday. He's better.
Okay. Are you his caretaker?
Well, yeah, I know.
No, it's not well, yeah, it's yes or no.
Yes.
You can verify that?
Not like, I don't get paid for it, but me and him live together, same house. And
Okay. And so he was hospitalized?
no, he wasn't hospitalized. He didn't feel like he needed to be hospitalized.
So you
He was
missed your PSI for something that you're facing 365 days in jail for. It just slips your mind. It's like, I forgot about it. I forgot I was facing 365 days.
That's true.
How?
How
How does one forget that they're facing 365 days?
Oh, I didn't forget that. I didn't forget the date, the time. I was just like.
Yeah, but you
well,
never showed up.
No,
It's been a
I
month.
did in the beginning. I did it the first, when I got out of jail. Yeah, I did the first part of the paperwork.
You were scheduled for pre-sentence interview July 21st, 10 a.m. The defendant failed to appear for this appointment. A letter was sent to the defendant's listed address requesting that the appointment be rescheduled. No response in 30 days. Do you know what today's date is?
Yes.
30 days later, no response from you. From the letter sent to you about you failing to appear per the court order for your pre-sentence investigation. Yeah, he'll be remanded so he can have a PSI. And don't you ever use a parent in here to tell me why you did not do what you were supposed to do. I can have sympathy and empathy for you having an ill parent, but you didn't forget that you were facing 365 days in jail.
Yeah.
No, you didn't. No, you didn't. You did not forget that. If you did, I can help you remember. Thank you.
No problem. We have a date for the sentencing.
I'm gonna have to give him, I have to give a new referral.
Okay.
For probation. If they have time to get him down while they're there today, they'll try to do it today.
Okay.
If they don't, then he's got to wait until they have time to do a referral via Zoom.
Good enough for me, Judge. Thank
Let
you.
me see if I can get a date.
October 8th at 9.
October 8th at 9. Thank you.
Thank you.
What are we doing with Dewey? Is that the one you're here on?
I'm here on two. Dewey is going to be a plea and Macon will be a waiver.
Okay, and Macon is downstairs?
Yeah, he's a youth.
I don't know if they
He's
forgot
here
to bring,
because
they
I
brought him
talked.
over. Okay. They
Oh,
called this morning saying they forgot.
Wait, okay, of course.
Yeah.
Mr. Fibers just ran out, so I can't ask about Evans. What matter are you here for? Piper?
Hayward, it's gonna be a waiver today.
Hayward? Oh, so you don't need it, those exhibits that you got. Look at that. We radio down for him to bring. uh, Hayward up, and then what are we doing with Evans?
We're finishing the exam.
Oh,
Addie to maybe.
Am I correct in assuming we're then waiting for someone to be brought up?
sorry,
Or am I correct in assuming we're waiting for
You
someone to
bring
be brought up then?
Alonzo.
we're gonna tell him to bring Hayward up.
Or to 30 seconds for me to approach them?
Sure. Ms. James, you approach? I got you. Okay, let's see.
I was looking for a break and hearings happening.
That is so. Okay, Hayward, we said it was gonna be a waiver.
Yes.
I'll get a head start on this paperwork.
Absolutely. Appreciate it.
And then. Dewey, you said was a waiver as well, or a plea? Dewey's a plea, and the other one's a waiver, got it. And. Gotta find these notes for evidence. It's not good.
What's that? Isn't it that one?
Huh?
That one. Over here, and then there's a-
What's wrong with it? No, this is not good.
Yeah.
Um, um, which ones? I probably need to look at this. Oh, this has to be it. I didn't put the name on it. Right, Maldonado? Yeah, this is it. Oh, so I'll play that. Terry Canvas was Nelly last week, right?
Also.
Mr. Abrams.
Okay, on the record in the matter of the state of Michigan versus Alonzo Hayward, this is in 26-1911. Have your appearances, please.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Gitche James on behalf of Alonzo Hayward, who is present and standing to my right.
Mr. Mayor was scheduled today for an exam on 2 counts of assault with intent to great bodily harm less than murder or by strangulation. And then there was 2 counts of domestic violence, habitual offender for defense notice as well. And my understanding is that both parties are waiving the right to exam today.
We are, Your Honor.
That is correct, Your Honor.
Was there an offer at all?
There was. The offer was to plead guilty to 1 count of assault by strangulation and 1 count of domestic violence. Negotiations are to continue upstairs. The offer remains open.
Ms. James, that's accurate.
That is an accurate statement, Your Honor.
And Mr. Hayward, you understand the offer, correct?
Yes.
You also understand that you have the right in this matter to have a preliminary examination on the felony charges here in the district court. And you're willing to unconditionally waive your examination? Anyone threatening you or promising you anything to do that? Okay, so that means you will not have your hearing at the district court level that requires the prosecution to establish that they have sufficient probable cause that the felonies were committed and insufficient probable cause that you committed those felonies. You understand? I'm sorry?
Yes.
Your bind over date is going to be September 2nd. That's the date the circuit court's receiving this file, not a district court, not a court date for you, that is, sir. Your next court date in circuit court is going to be a pre-trial, okay? Your attorney will be made aware of that. Do you have any questions at this time? A bond was set at 15,000 cash surety with GPS tether and victim notification. Any additional matters for the record?
Not behalf of the people, Your Honor.
Not for defense, Your Honor. Thank you.
Bond will continue. You're all set.
Thank you.
Thank you, Your Honor.
Judge, you want any else? No.
Absolutely. I think everybody's in custody. So you can bring up Macon next.
Macon, okay.
Dewey is not incarcerated. I didn't help you with that.
I did.
Okay.
State of Michigan versus Edward Dewey, 26-01535.
Ross Marchino for the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Dewey, who is present.
Okay, so Dewey was scheduled today for an examination. And this was for assault with intent to do great bodily harm, and then there was a domestic violence. My understanding was there's going to be.
Yes, Your Honor, that is correct. People made an offer in which the defendant would plead guilty to domestic violence with consent to 769.48 status.
Mr. Carter, you can give him his. Okay, Mr. Dewey, that's how you want to proceed?
Correct.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay. And this is an advice of rights into the information sheet. There's a signature on it. This is today's date. Is this your signature?
Yes.
You went over these rights as your attorney, correct?
Yes.
Do you understand all of these rights?
Yes.
You also understand that you would need to waive or give away each of these rights in order to plead guilty to domestic violence?
Yes.
So that means you're going to waive or give up your right to the presumption that you're innocent until proven guilty, and your right to require the prosecution prove your guilt by proceeding to a trial and having them prove each element beyond a reasonable doubt. You understand that? You're going to give up your right to see, hear, or question in court any witness that they call to testify against you, and the right to have witnesses subpoenaed on your behalf to give testimony, and the right to present evidence that you believe show a defense to the charge being brought against you. You understand that?
Yes.
You also will give up your right to remain silent and not have silence be used against you. Is that what you want to do as well?
Yes.
Is anyone threatening you to get you to give these rights up?
No.
Any promises being extended to you in exchange for a guilty plea today?
No.
Are you on probation or on parole?
No.
You understand that by pleading guilty, it could result in a conviction that you may need to report to a current employer. You may need to put this on a future job application. You understand?
Yes.
It also could have impact on where you can travel or get immigration status. So you may seek to travel out the country in the future somewhere. They could deny you access to their country because you have a criminal conviction. Do you understand that?
Yes.
Okay. As to count 2 of domestic violence, how do you plead?
Okay.
Is that because you believe you're guilty? A factual basis, counsel?
Thank you, Your Honor. Mr. Dewey, on or about June 2nd of 2026, were you in Hingham County?
Yes,
And that was City of Lansing
yes,
at 1400 Pico Avenue?
yes,
That's your residence, correct?
correct,
And you were there with your wife Keely?
yes,
And at some point in the evening of that day, there had been an argument between you and her, is that correct?
correct,
And you ended up assaulting her, isn't that correct?
correct,
You ended up pushing her against a wall, correct?
correct,
That was not done in self-defense, correct?
correct.
I have nothing further.
People are satisfied with factual basis, Your Honor.
Before is satisfied with the factual basis, trial accept your plea and find your plea to be free, voluntarily and intelligently made. A sentencing is scheduled for October 8th at 9 a.m. And when you leave here, you're gonna go downstairs to check in with our probation department. They'll get you set up for a pre-sentence interview. You will fill out some paperwork. The interview will be scheduled. You are required to return for the interview. Do you understand that?
Yes,
Were you here when you saw what happened? If you don't return to the interview,
yes.
you go to jail.
I don't like
Okay?
that.
Yeah, I don't think you do, especially if you're looking for 769.4A, which means you would do a term of probation. You can't follow court orders now. I don't see how you can follow it later. I am going to require, I believe, a substance abuse assessment in this case, just because the affidavit of probable cause speaks to intoxication. So you will be required to do that prior to your sentencing, okay?
Is that something probation does? Or
They
do I
can do
need
that.
to-
No, they'll take care of all
All
of that.
right, thank you.
They'll take care of all of that to make sure he's all set. And you can appear for your sentencing via Zoom, if you'd like, okay?
Okay.
You have any questions at this time?
No.
Okay, we'll get you a notice, and then when my officer is available, he'll take you downstairs to probation, okay? Any additional matters for the record?
Nothing from the people.
Nothing for the defense.
Thank you, you're all set.
Some basic information, set up an interview date that can't miss that. Okay.
Oh, today must have been my PCC day. Isn't it? Oh.
Means we're probably gonna get clobbered our next PCC day.
Can we though? Because we just have like 30 exams scheduled last week, or like,
Yeah.
I think the system's supposed to even itself out at some point. Should.
They probably think they're evening it out by not giving us PCCs this week.
I don't know about 30 at one time.
That was insane. That
Yeah.
was-
Yeah, it was like, I think that, well, that's because they never, when we do the judicial conference, we don't block our calendar. We're not supposed to block our calendar. We're supposed to draw our cases. And then at the PCC, we each try to dwindle it, the docket down, because we typically are all at this conference. And then maybe Judge Felice or Judge DeLuca will cover our docket, and they'll do whatever exams we couldn't waive or reschedule. Well, this year they forgot about that because, oh, well, Judge Simmons will be here. So everybody blocked their calendar. So I do everything.
Okay, that's crazy.
They're like, how did you get so many? You all blocked your calendar. That's out. Okay, this is Mr. Macon. Is that correct?
Yes.
Okay, this is the state of Michigan versus, is it Timaeus? How do you say your first name, sir? Timaeus Macon, 26-00864. Can I have your appearance, counsel?
May it please the court, David B. Carter Jr. on behalf of Mr. Mayor.
Morning, Your Honor, Natalie Mason, on behalf of the people.
today was the date that was scheduled for a examination. This is for assault with intent to murder, carrying concealed weapons and felony firearm. And my understanding is that we're not going to be having an exam, is that correct?
That is correct, Your Honor. Both people in defense will be unconditionally waiving the right to hold a preliminary exam in this case, but ask the court find this case over on the charges in the complaint. There's an offer to place on the record, however, Your Honor, and that is the defendant at the First Circuit Court pretrial will enter a guilty plea to an added count 4 of felonious assault and also to count 2 of weapons carrying concealed. Upon successful plea and sentence, the balance of the information will be dismissed. There'd be no objection to HYTA status if eligible. People do believe the defendant is eligible for HYTA.
Mr. Carter.
And release them. Oh, yeah, that's right. That's not her. That is a correct statement, Your Honor. There is an additional agreement that he'll be released today on tether.
If the court allows.
That can't be a part of the offer. Right. That could be a motion that you make.
Inappropriate, Your Honor, if I can make a record about how we're proceeding today and the way that came about.
Yes, and just a moment. Yes.
Mhm.
Okay, Mr. Macon, how are you? Okay, and so you understand that you did have the right, or you do have the right, that is, to have a preliminary examination here in the district court. Okay, do you understand the purpose of the preliminary examination? Okay, so the purpose of the preliminary examination, it's a hearing that requires the prosecution to first meet the burden that they have sufficient probable cause to charge you with the felonies that were committed. So they have to first establish that there's sufficient probable cause that a felony was in fact committed, and then probable cause sufficient to charge you as the person who have allegedly committed those felonies. It's a very low burden of proof that they have, but it's still something that you can require them to do for your rights. You understand that? Okay, and you've counseled with your attorney, you wish to waive your right to have that exam?
Yeah.
Okay, and no one's threatening you to do that, correct?
No.
No one's promising you anything if you waive your examination? Okay. Okay, so your bind over date is going to be a September 2nd. Bind over date means the date that we will send the file from this court over to the circuit court. There will not be a next court date for you unless your attorney files a motion for you to be rearranged in person at the circuit court level, okay? Okay, otherwise, your next court date will be a pre-trial in the circuit court. Your attorney will be made aware of that. It is your responsibility to stay in contact with your attorney throughout that time, okay? Do you have any questions for the court? Okay, you wanted to make a record, counsel?
Thank you, Your Honor. Your Honor, up until late last night into early this morning, my office had been in contact with the victims in this case, and at least with the parents of the victim in this case. When I spoke with the victim's mother last night, upon learning who I was, she terminated the phone call. I spoke with the victim's father last night. He spoke with me, but said that his understanding was that the victim would not be here. She would not live with dad. That mom would not be bringing her for a lot of reasons. That backstory that is not necessarily important to this court, but she would not be participating. This case was caught on camera, so we would be able to proceed via law enforcement officers. However, the officers that could ID both the victim and the defendant were not subpoenaed for today because we did not anticipate this being a question. So the kind of options that we were left with were either to do our circuit court negotiations now, in anticipation of a waiver, or obviously the court would have, we would not be able to proceed today, the court would dismiss, we would have to reissue and go through the entire process all over again, which just kind of seemed like a waste to everybody. So I approached Mr. Carter very early this morning with what both the developments that had happened, with the offer that was placed on the record today. Also, in contemplation of that offer, obviously, as the court is aware, the defendant does not have any criminal background, history, juvenile or adult, and different factors of that nature. So we wanted to make a record of how all of this came about and why it was all kind of last minute as opposed to what would normally happen in a case with charges like this.
Thank you. And that's your understanding as well.
That is accurate, and I'd also indicate that if in fact they were not able to proceed and I was successful in getting the case dismissed, I explained to my client that it would be without prejudice, and that the prosecuting attorney has indicated to me that they would reissue, which would start everything all over again, and that even if they didn't have the victim participation in the case, they felt like their case was strong enough to take to a jury. I explained all that to my client, so he fully understands why this offer is and why he would like to waive the preliminary exam and proceed to circuit court where the case will be disposed of one way or the other.
So that is also your understanding as well, correct, sir? Okay, and even with that understanding, he has explained that he was freely and voluntarily waiving his right to have an examination based off what the prosecution is saying. I don't know that the case would have even been dismissed, but it sounds like they can proceed with other evidence, at least to this point. With that being said, the case is now bound over, but you did want to address bond.
I did, and I know that it's not part of the agreement, but it's my understanding that the prosecutor would not oppose my motion for a bond, for a PR bond with GPS tether. My client has been incarcerated, I think, since May 26th. He's been in the youth center because he's under the age of 18. He has no troubles at the youth center. He tends to follow all the rules. He has not been an individual who is making trouble. He doesn't have a record. He has the support of his family, whom they are here today. So I'd ask the court to allow a personal recognizance bond on GPS tether.
He was arraigned at least April 30th by the magistrate, so I would assume he's been in custody since April.
Yes, I'm sorry.
Okay, and the magistrate did impose a high bond, $750,000 cash surety with GPS tether and victim notification. And other restrictions, and that it seems he was housed at the youth center. The allegations are quite concerning as it relates to what was alleged to have occurred. And obviously, as now we have him facing assault with intent to murder and CCW and felony firearm, even without the offer. That's what you're facing. Those are very serious charges. So I think that the bond originally was appropriate. He's young though. How old is he?
How old are you?
15, that's what I have here, that he was 15 in May. I remember he was reluctant to even speak to his attorney without his parents being here. So that's a good sign for him. Looks like he's at this point relying on you all as his parents, for guidance, which is what we would need to see. And so I'm inclined to grant a reduction in bond, but not for him to be roaming freely outside. Is he in school or something? Okay, so he's supposed to be starting school on Monday. Well, I guess we gotta get you back at school. They'll let you in there. I will grant a PR bond with tether, and you will have a curfew, which shouldn't be a problem because you're only 15. And so you will be allowed to leave, I think which is what the magistrate originally said anyway. You can leave the residence for medical, dental appointments, court hearings. She didn't mention school, but we will mention school. And school, and if you have a job, you can leave for those purposes without further permission. If you need to leave for anything else, you gotta get permission from pretrial services, okay?
When you say court hearings, I'm assuming legal counseling would also.
Of course, legal meeting with your attorney will, is a court-related hearing or meeting. So those are fine. Those are court-related appointments. But if you're trying to go to an event or something to that effect with your family or whatever, they just need to make a request to pretrial services so that we know that you're going to be under their supervision for that purpose, okay? You understand that? Your mother is nodding that she understands. So that's important that we all understand that you're going to be released really for the purposes of getting back on track with school and not having to sit inside the youth center. I'm happy to hear that there hasn't been any issues and that you've been having good behavior while you're there. You've been more than polite and mannerable when you're here. So just by the way you've been presenting yourself in court, does not appear to be something that I would have expected someone like you to find yourself into. So hopefully the future for you does not include anything like this. So I will amend the bond per my previous statements. That order will go in for today. So he will go back to Ingham County and then be released there with tether.
May I inquire, is the court going to keep victim notification on? And if the court is, can it make a note of only if possible? Because I'm not sure that JSG will be able to.
I think it was if possible.
Okay.
Before, let me double check.
Don't want that to hold them up if they're not.
It does say if possible.
Okay.
It was, yeah, it's with if possible. So it sounds like the victim is not willing to participate for some reason, and that's fine. We don't, we won't tie his GPS tether up to that. Okay. Let's see. So for the purposes of a clear record, bond is admitted to 100,000 personal recognizance with GPS tether. And victim notification if possible. And I noted that you're allowed to leave the home for school, church, meetings with your attorney, court appearances, and medical appearances. Other than that, you should be at your home, okay? What is your address? What school do you go to? I'm sorry? There was an apartment, you said apartment 112?
Yeah.
Okay, and your phone number, do you have one? Okay. Mom, can I have your phone number, please?
517-770-9282.
Any additional matters for the record?
None of the people, thank you.
None for the defense. Thank you.
No, but
Thank you.
Thank you.
and then we need Evans brought up. And then we gotta take this guy down to probation.
Do you want me to escort him down?
That would be great, thank you.
Thank you.
That was Dewey.
Yeah. Thank you. Oh, okay.
This is Evans. Okay, on the record in the matter of the state of Michigan versus Thomas Evans, I have 26-01636 and then 26-01637 appearances.
Ross Marchino for the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Thomas Evans.
Okay, Mr. Evans was scheduled to continue examination today. I think we were looking for testimony from Lydia Chapello. Is that correct?
Yes, Your Honor, that is correct. Unfortunately, Lydia Chapello, is not here. We are hoping to take testimony from Zachariah Vanderwerf, at which point we will rest and seek find over from there on whatever is supported based on what we have.
We know why Ms. Chapello is not here.
I've been texting and calling and
She's not on leave though, right?
I have no information that she, a couple weeks ago, she was out of the country on vacation. I checked and her subpoena was open. I don't have an explanation for her not being here. But, obviously I can't ask for more time again and say what we'll see what we can.
Okay, any other matters before we call your witness?
None on behalf of Mr. Evans, other than this question, I couldn't see any of the other witnesses here.
Yeah, Zachariah Vanderwerf is the only witness on this case who was present. People call Zachariah Vanderwerf.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
State your first and last name and spell both.
Yeah, Officer Zachariah Vanderwerf, first name is spelled Zachariah, last name is spelled Vanderwerf, capital WERF.
You can proceed.
Officer Vanderwerf, how are you employed?
With the City of Lansing Police Department,
And how long have you been so employed?
9 years.
What is your role with the City of Lansing Police Department?
I currently work with DCI, which is our Violent Crime Initiative.
And what responsibilities do you have?
Our overall goal is to help reduce violent crime in the greater Lansing area.
And were you working in that capacity on June 19th, 2026?
Yes,
And on that date, Were you summoned to assist with finding a suspect in the shooting case?
Yes,
What was the name of the suspect?
Thomas Michael Evans.
And were you given information about a place where you might be able to locate the suspect?
Yes.
And where was this location?
So the location was like the Pine Brook Manor Apartments. It's like 5921 South Waverly Road.
And those apartments, are they in the city of Lansing?
Yes,
Is that in Union County as well?
yes,
And were you also given any information about a possible vehicle he might be located, might be found in?
yes. Silver two-door Ford F-150.
And that was information that was relayed to you from others?
Yes,
And did you go to this location and conduct surveillance?
yes, I did.
Were you with anybody else?
Yes, I was with Officer Kilborn and Eaton County Deputy Kerrigan.
And did you guys have any success finding this vehicle?
Yes.
And where was the vehicle when you found it?
So the vehicle was at 50, I think it was parked outside of 5913 South Waverly Road, which is where we were doing surveillance on it. And then Officer Kilborn notified me over the radio that the vehicle at some point after our surveillance was leaving.
And what did you do when you found out the vehicle was leaving?
So he advised us that I was driving eastbound through that particular complex over there. So I took my unmarked police vehicle and drove to a location of where that vehicle was at. And then I parked in front of it to prevent it from driving any further.
And was there a time when a traffic stop was initiated?
Yes, so my partner, Eaton County Deputy Kerrigan, he has an unmarked police vehicle as well, but it's outfitted with blue lights and sirens, or red and blue lights and sirens. And so he activated those as we pulled up to the vehicle.
And at this point, did the vehicle stop?
Yes,
And just to make sure I'm understanding, was your car parked in front of the vehicle at the time it was stopped?
yes.
And then did you approach the vehicle?
Did not approach the vehicle, no. Initially, I stepped out wearing just like my outer carrier vest that has police markings on the front of it. And then we began giving him commands to get out of the truck.
And when you say him, are you referring to Thomas Evans?
Yes,
And do you see Thomas Evans in the courtroom right now?
yes, I do.
Could you please tell me where he's sitting and describe his clothing?
Yes, he's sitting right there in a blue jumpsuit.
For the record, the witness pointed towards the defense table, and Your Honor, could the record reflect that the witness did identify the defendant?
Any objection to identification?
None, Your Honor.
Identification noted.
Where in the truck was he sitting?
He was in a front passenger seat.
And who all was giving commands to exit the vehicle?
Myself, Officer Kilborn, and Eaton County Deputy Kerrigan.
And were any of you in police uniforms?
So we all wear like plain clothes as typically our uniform, but we all wear like an outer carrier vest with police markings on it.
What time of day was it when you were?
It's daylight.
And how many vehicles had, I guess, police sirens go, the police, the lights go? If you were.
For my recollection, only Eaton County Deputy Kerrigan's that I'm aware of.
And did anybody identify themselves as police officers, or did you allow the vests and lights to speak for themselves?
At least from my standpoint, I allowed the vests and the lights to kind of speak for themselves.
And do you recall how many people gave Mr. Evans commands to exit the vehicle?
At least 3.
And were you one of those people?
Yes.
And what, if anything, did he say when giving these commands to leave the vehicle?
It was difficult to hear him from where I was, but basically we were just giving him commands to get out of the truck and to keep his hands up, and he was not. And it took us probably approximately 5 minutes, even before we ended up approaching the vehicle. But at no time did he get out of the truck.
And were the circumstances such that you were able to have an opinion as to whether he could hear you telling him to exit the car?
Yeah, I mean, you could tell that he was responding to us when we're yelling commands, like he was saying things, like you could read his lips, but it's just, I couldn't make out what he was saying.
And did anything eventually happen that caused him to comply with the commands and exit the truck?
Officer Howard at one point approaches the driver's side of the vehicle, and he had his taser out and he was giving him commands to get out. And then at that time, I believe Officer Howard was going to utilize his taser, so I approached the passenger side of the vehicle.
And when the taser is, I guess for lack of a better word, brandished at this point, did he step out of the truck?
So the door opens and he was beginning to step out, but he had not fully stepped out of the vehicle.
And was he making any sort of movements that caused you concern?
Yeah, so I mean, even during when we were giving him commands, for one, he had a glove on only one hand, which was concerning. Typically, what we'll know from those situations from BCI is that people wear gloves when they carry or conceal firearms or when they use them in crimes so that DNA will not be found on the weapon.
And which hand did he have a glove on?
It would have been his right hand.
So based on your training experience, just make sure I'm understanding, having a glove on only your right hand, is that consistent with carrying or using the firearm?
Yes.
And so circling back to before and exiting, when exiting the vehicle, can you explain what, if any, movements he was making that were concerning to you?
Yeah, so some of the concerns were he continued to drop his hands when they're giving commands to keep him in there. And also, once I approached the truck and we were going to get him out, I watched his left hand start to go down towards the floorboard of the truck.
And at this point, did you begin to physically extract him from the vehicle?
Yes.
And was he compliant when you physically removed him from the vehicle?
No.
Can you please explain the manner in which he was not compliant?
So when I pulled against him to pull out of the truck, he pulled back against me.
And what steps did you take in order to get him to comply?
So just using strength and leverage, myself and Officer Kilborn, we took him down to the ground.
And at this point, we were able to effectively take him into custody.
So we were able to get the right hand behind his back, but the left hand was still underneath him. And I saw officers struggling to pull that arm out. So in order to get him to release that other hand, I struck him approximately 4 times with a close fist on the right side.
And then did he eventually release that hand?
Yes.
And striking him, was that a pain compliance technique?
Yes.
And upon having him, well, taking a step back, did the driver of the vehicle comply with commands to exit the truck?
He did.
Did he promptly comply, or was there a delay with him?
No, he pretty much got out of the car almost immediately when we stopped him.
So it was only the passenger, Mr. Evans, who did not comply.
Correct.
And was anybody else in the truck?
No.
Now, after successfully getting Mr. Evans into custody, did you make any observations of anything in the truck?
Yes, I observed a firearm on the floorboard of where Mr. Evans was sitting from plain view.
So where Mr. Evans was sitting, we referring to the front passenger seat?
Yes.
And where was it relative to the seat?
So front passenger seat where he was sitting, it would have been like right underneath where he was at.
So where he was sitting, would it have been easily accessible to him?
Oh, yes.
Would it have been easily accessible to the driver?
No.
And did you then recover that gun and take it into evidence?
Yes.
Can you sort of describe the gun for me?
Yeah, so it was a black Smith & Wesson M&P 40 caliber pistol.
And did it have any ammunition?
Yes.
Can you explain how many, if any, rounds it had?
So there's 22 total rounds of ammunition. It had an extended magazine, and then there was 1 round in the chamber.
I think I already asked this just to be sure. This happened in the city of Lansing, County of Bingham.
Yes.
No further questions.
Thank you. Good afternoon, officer. Good morning, excuse me.
Good morning.
So you've been an officer, you said, for 9 years, is that correct?
Yes.
And how long have you been in violent crime division?
Since January of this year.
That's so relatively recent, then, right?
Yes.
And I'm sure before you do any training before you went through BCI, you get into BCI?
No, only the trainings that we've been to as a road patrol officer.
Okay. And you mentioned, and obviously, before you were an officer, you went through the police academy, is that correct?
Correct.
And you were probably trained to make an investigation, is that correct?
Yes.
And as well as how to make a police report, is that correct?
Yes.
When you made a police report in this case, is that correct?
Yes, I did.
And at the time you wrote, you believe it to be accurate and truthful, the best you believe?
Yes.
Have you reviewed it since?
Most of it, mostly kind of skimmed over before I came in here.
But after reviewing that, you found it still to be true, accurate, and correct from your memory of that day?
Yeah.
Okay. And you said that night you come into contact, you get a dispatch out, so you come out to the scene and come in contact with a pickup truck, is that correct?
Yes.
And you've never seen that pickup truck before, is that correct?
Not before that day, no.
And you didn't know the driver or the passenger, is that correct?
I knew the passenger, but only as I pulled up when we made contact with them for the traffic stop.
So you never met him before that?
No, I never met him before that.
Okay. And did you run the plate through Lee before you got there?
I did not personally know.
Do you know who the owner of the car was?
I did not.
Okay. And you said you gave commands to both the driver and the passenger to get out, is that correct?
Yes,
And you said the driver complied, is that correct?
yes, he did.
Did you talk to the driver?
I did not.
And you said you looked in the car, is that correct?
Yes,
Did you find any personal belongings belonging either to the driver or to Mr. Evanson?
the only thing I can recall finding was the gun.
Okay. And you said the gun was under the floorboard, is that correct?
So not under the floorboard, but it was on the floorboard underneath where Mr. Evans was.
Is it possible that someone else could have placed it there had they been in the vehicle 20 or 30 minutes beforehand and people could have never even seen it was there? Was it easily discoverable?
I guess that's possible.
And you mentioned that Mr. Evans had a glove on his right hand, is that correct?
I believe it was the right hand.
What kind of glove was
It's like one of those, the best way for me, like mechanics gloves, it's got like the rubber, kind of like the rubber on the inside almost.
it? You can use that for many purposes, is that correct?
Yes,
You can use that for fixing things, is that correct?
yes,
And you said it's typical for people that hold guns to have one glove in their hand, is that correct?
yes.
So there are other things besides that, like mechanics or say baseball. Maybe we have just a glove on, is that correct?
Yeah.
Or golf.
Yeah,
I'm sorry, was this a baseball glove?
it was not a baseball glove.
But sometimes people use different.
Are you
things.
asking him?
But sometimes people can use different gloves for baseball. It doesn't have to be batter's glove.
Yeah, I guess that's possible.
I
Yeah.
mean, I've seen it, but in rarity. I think I may have done it once when I lost my glove. and I had to
I'm
buy
gonna
it.
object at this point.
Yeah,
Yes,
fair enough.
James.
Sorry. Fair enough. And you said that, did you do anything else besides find the gun at the car that night?
No, I don't think so.
And did you have any contact with the passenger that night?
The driver?
Yeah.
No.
Okay. Or the passenger, is that correct?
I did have contact with Mr. Evans as far as extracting it from the vehicle.
But outside of that, you didn't take a statement or anything else?
No,
All you did was just find the gun and process and take it back to the patrol car, is that correct?
yes,
Okay. You do anything else since that day?
no.
Okay. No additional questions?
Can you redirect?
Can you sort of describe the glove a little bit that he was wearing?
Yes, the way that I describe it is that they're the kind of gloves that, at least from what I remember, because I used to work in a factory at like Cintas before. So they use these gloves, it's got like the rubber on the inside and that's kind of the cloth on the outside is what it looked like. Go for the redirect, thank you.
Thank you, officer, you may be excused. The additional witnesses?
They are, the people are going to rest now on both files.
Is the defense calling witnesses on?
None for a person previously set this morning, Your Honor.
Thank you. Okay, so starting with the 1636 file, which was the May 15th incident charge as discharging a building, felony assault, and 2 counts of felony firearms. Obviously, the primary witness in this case on this file was Ms. Ryan Maldonado, who I would suggest became less forthcoming and less credible as the testimony went along. Starting with this one, if memory serves, she testified about having an argument. She could identify Mr. Evans, described having a domestic relationship with him, and described having had some sort of argument that culminated with him brandishing a gun and then firing it into the air. She, of course, denied him firing the gun at the building, which obviously is going to repeat one of the charges. And we, of course, were not successful in procuring testimony to the contrary on that. Moving on to the charges that we do have, we have count 1, discharge at a building. People are going to have to move to dismiss that count because we, of course, did not have any evidence that he discharged at the building. However, count 2 is felonious assault with a dangerous weapon. There's not testimony suggesting that he pointed the gun at Ms. Maldonado. However, I would submit that, in the context of an argument, removing a gun and then firing it in the air certainly is an act that would put someone in reasonable apprehension of shortly thereafter being shot at with that fire. So I do suggests that we have probable cause on count 2, which is the felonious assault. And then count 3 is the felony firearm as attached to felonious assault. And we're going to request find over on counts 2 and 3, and dismissal of counts 1 and 4, which are the discharge of the building and the felony firearm connected to that. I also am going to ask for an added count 5 domestic violence, which just is an assault plus a domestic relationship, which of course is a misdemeanor. And I don't do, make a point of that just because there currently are no probable cause findings on that charge. And now, of course, the bigger file is the 1637 one. We of course had a lot of witnesses. Some of the testimony came in and not exactly how I anticipated, and as a result, some of the testimony was kind of redundant. I do apologize for that. I do value judicial economy, so I don't want to tout in more witnesses. But getting into the charges, well, I think that evidence establishes that Ms. Maldonado was at this home with Mr. Tavares Brown, I believe that's his name, Tavares Brown, having a relationship that I don't think either of them are particularly proud of. And it sounds as though Mr. Evans came over and was not happy at the sight that he saw and took out his gun and fired 2 rounds into this home, one of which shot Mr. Brown and the other one missed, who I believe was the intended target, Ms. Maldonado, traveled through the other wall in the trailer and then went into the different trailer behind it, coming dangerously close to striking an infant. We heard testimony from Mr. Brown about seeing Thomas Evans outside, and shortly thereafter, the gunshots occurred. We had testimony from Miss Pratt about hearing what she hoped was a car backfiring, but knew on a certain level was a gunshot, and describing Mr. Evans as the person who appears consistent with the person who she has seen arguing with Miss Maldonado before, and described this bullet hole and damage to her house appearing. And then we of course had testimony from Officer Olson explaining that there was a clear path from the bullet hole in the front of the trailer to the bullet hole in the back to the bullet hole in Ms. Pratt's home. And we'll get to the implications of that as far as the charges go. And then we had testimony from Mr. Fisher, who saw a person who appeared to be this defendant walking away, stuffing something into his pants, which we don't have enough there to add a CCW from that, but legal minds can infer there's a good chance what he's doing with a firearm, and then leaving in a truck. And then obviously our testimony from Ms. Maldonado is such that I would suggest lack credibility as far as her testimony, that she did not know who shot, didn't see who shot the gun. It obviously she was only a few feet away from the person who we are alleging to have done that, and was right in front of his family, his loved ones here to support him. Domestic relationships in general, these sort of showing up and then suddenly not following through is very common, as Your Honor knows. And then there's just some added levels to there having been gun violence involved and having family in the room, things like that. Which obviously we had testimony from Mark McGonigal under 27C that suggested at that time she was willing to name Thomas Evans as the person who she did see fire the gun. Then of course, we had the testimony from Officer Applegrain regarding she was able to get an excited utterance at the time, suggesting yes, it was Thomas Evans. And that information, of course, wound up being relayed out to other officers, which led us to Officer Vanderwerf, who partook in initiating this traffic stop, at which point in time Mr. Evans refused commands to exit the vehicle. And when he eventually was forcibly removed from the vehicle, they found a gun within easy reach of Mr. Evans. So anyway, getting into the charges, count 1, we have assault with intent to murder. And that count is with respect to count 1 is with respect to Tavares Brown. The intent to, I won't get bogged down in the elements in each of these because I think some of them are pretty straightforward. When you shoot someone, we can infer that the intent is to murder. I think that there could be a jury argument regarding, oh, well, he got him in the leg. Maybe he was just trying to scare them. There are arguments that can be made to a jury, but especially given the evidence of motive and the evidence of 2 shots, potentially 1 per person in the trailer, we can infer on a probable cause basis the intent to murder. And the order of the counts is kind of interesting. We have count 2 now is carrying concealed weapons. So we're going to sort of I wonder, we're gonna have to amend the information on this because it's looked like the location for this CCW, despite the language being in a vehicle, is giving the location of the trailer. I do believe we had testimony from Officer Vanderwerf regarding the Waverly address. So we'll need to amend that language. But the instruction for carrying a pistol in a vehicle would be 11.1A. First, the pistol was in a vehicle the defendant was in. The testimony from multiple witnesses is clear that there was a gun on the passenger side floorboard of this vehicle. Third, that the defendant took part in carrying and keeping the pistol in the vehicle. I think that there's a couple factors considered here. One is that it was right at the defendant's feet. Two is that we have a lot of testimony suggesting he very recently was in possession and was using a firearm, a pistol specifically. And then, of course, we had testimony regarding the glove that he was wearing, which Officer Vanderwerf indicated is consistent with usage of firearm. So I would request find over on count 2. And then count 3 is the resisting or obstructing a police officer, which is pretty straightforward. There is clear disregard for lawful commands to exit the vehicle. We can establish legal lawful commands because evidence from the scene did suggest that this individual had fired 2 rounds at Kavaris Brown and Mariah Maldonado. And this information was relayed to the DCI officers who then went and conducted surveillance, found the suspect's vehicle, and then initiated a felony stop and issued lawful commands to exit the vehicle, with which he refused to comply, and then there was some additional physical resistance. It looks like it's charged as Peter Howard. I think it would be more appropriate for that to be charged as Zachariah Vanderwerf. So I would request to amend count 3 to be Zachariah Vanderwerf. Now, count 4, we have discharge at a building. That one pretty much speaks for itself. There is a minimum probable cause that he fired at this, what was described as essentially like a mobile home that was clearly potentially dwelling or potentially occupied structures. Count 5, assault with intent to murder. This count is for Mariah Maldonado, and sort of the same argument. The fact that his aim was not quite as good with Miss Maldonado. Perhaps that could be an argument. Well, he missed, therefore he was just trying to scare. But as far as probable cause goes, I would submit that there is sufficient evidence to find this over in the circuit court. And then we get into the felony firearms. Count 6 is count 6 and 7 are both felony firearms connected with the AWIMs. The evidence is clear those were committed with guns, and so I'd respect find over there. And then count 8 is felony firearm for discharge at a building, and I would request find over there as well. And then count 9 is a misdemeanor. We don't need to make probable cause findings there. Now I'm going to request an added count 10, which is a second count of discharge at a building. This is for Miss Pratt's home that was also hit. And I will take us over to the transfer intent instruction 16.22, which I've noted previously is constructed around homicide, but can translate to other crimes as well. If the defendant intended to kill one person, but by mistake or accident kill another, the crime is the same as if the first person had actually been killed. Obviously, you could adjust it for this crime, but his intent was to shoot one of these mobile homes, and then the bullet went through it and struck another mobile home. So his intent to shoot Miss Maldonado's home transfers to Miss Pratt's home. And so I would suggest that under the transfer intent, we do have a second count of discharge of the building. So I'm going to also request an added count 11, a felony firearm connected to that count of discharge of the building. And then,
I'm sorry, you said we want to add a count 10 of discharge of the building.
yes,
Okay, and then a felony firearm.
yeah, and then a felony firearm with that. And then I'm going to request an added count 12, which is a felony firearm to connect with the resisting or obstructing a police officer. And possession with that one is going to take us to 11.34B. Felony firearm possession. There are 2 options, and we're going with option 2. The person knows the location of the firearm and has reasonable access to it. He's disobeying lawful commands from police officers while sitting in this vehicle with the gun right below him. Officer Vanderwerf was quite clear that he had quite easy access to it. And as we discussed, there is plenty of circumstantial evidence from which we can conclude that he knew that the firearm was right there at this point in time. So we're going to request an added count 12 felony firearm connected to the RNO. And then finally, we are going to request an added 13 misdemeanors and domestic violence. Thank you.
Yes, Your Honor. Thank you. I'll start with the first case that you mentioned. Your Honor, obviously, he's willing to dismiss count one, so I guess I'll take no objection to that. I want to start with count two and count three, the felonious assault. Obviously, we heard testimony, there was some disagreement between Mr. Evans and Ms. Maldonado, at least according to Ms. Maldonado. What we don't know is he fired the gun in the air. We don't know if she was afraid that she was going to get shot. There was no testimony, no evidence to suggest that she was, or even that she was scared, because it's part of the intent of the person has to be afraid. There's been nothing to suggest that. So if you find that count two isn't lawful, then there is no count three. And if we're going to add a domestic, I don't see the purpose to that. I would ask that that also not be added on. Let's go to the other file, Your Honor, with regard to count one. I know it's a low standard of proof, but I don't think they've met their burden with regards to that count. The same can be argued for count two and count three, Your Honor. I think the big issue here to me would be the counts 10, 11, 12, and even the 13, Your Honor. I think if you look at the transfer of intent that he argued, that applies to homicides. We don't know anything with regards to he's a bad shot. We don't necessarily know.
So you don't know what?
Draw that, Your Honor, and something I don't want to say, so I'm gonna move forward on that. But so that will follow count 11. With regards to count 12, the firearm on the RNO, we don't know from the officer if he found a gun. There, no gun was utilized. He didn't comply, but I don't necessarily know if he had the gun in his possession. He certainly didn't threaten the officer with a gun. It was under the floorboard. There was no mention he had it or reached for it or said, "I've got a gun." I don't think that charge is absolutely necessary. It fits with the facts. I think we can make the same argument with adding another DB. Thank you.
I think that two quick points I would add is that actual fear of a battery is not an element of felonious assault. And looking at 17.9 must do an act that would cause a reasonable person to fear. I would suggest that a reasonable person who sees someone they just argued with pull out a gun and shoot in the air would fear an immediate battery. And I just would want to clarify that Officer Vanderwerf's testimony was not the gun was under the floorboard, that it was on top of the floorboard. Thank you.
Okay. Today concludes the preliminary examination on two separate felony files. Again, one ended in 3-6, one ended in 3-7. The purpose of the preliminary examination is for the prosecution to establish whether or not they have sufficient probable cause of the felonies you've been charged with were in fact committed, and then probable cause sufficient to charge you as the persons who have allegedly committed these felonies. So this is not trial. They don't have to prove each element beyond a reasonable doubt. They just need to show the court more than mere suspicion that the actions took place, and anything that could result in a question of fact that has to go to a trier of fact. The court is the sole determiner of credibility at this stage, and the court also is in the position to weigh the people's likelihood of success on the charges if they were to proceed to trial. So again, taking case number 26-01636 first, the defendant again is charged with weapons, firearms discharged at or in or at a building. Count 2, assault with a dangerous weapon, also called felonious assault, and then weapons, felony, firearm. Again, we did start with testimony from Mariah Maldonado, which consistent with what the prosecution has argued. She was less than forthcoming. The court did not find her testimony to be fully credible. It sounds like she was trying to evade answering or either all of the questions or answering fully and truthfully to give the court a reasonable understanding as to what took place. But she did testify that on or about May 18th, that she was at the address of her home, 3407 West Mount Hope, which is a trailer park where she resides. She said she was inside the trailer arguing with the person she identified in the court. And that when he was leaving, they were on the stairwell while they were, I guess, still arguing. Defendant was then on the street. She said she saw a weapon. She said it was nighttime. She described the weapon to be a shotgun style rifle. She also described that the defendant was at the time, or she was at the time intoxicated, is what she described. And that the defendant discharged, she said, a firearm into the air. I would agree that count one, we don't have sufficient probable cause to continue on the people's request to have that dismissal granted for lack of probable cause. The assault with a dangerous weapon, felonious assault. So the people would need to prove at least at the time of trial, beyond a reasonable doubt that the defendant made an assault upon Mariah Maldonado with a dangerous weapon, that being a handgun or a rifle, if that's what you described, but without intending to commit the crime of murder or to inflict great bodily harm less than murder. And the prosecution, all the defenses argued that there's been no testimony or evidence that would, from this alleged victim, that would support that the defendant intended to assault her, that she felt threatened. And again, the court found her to be evasive with some of the information. Whether she was being evasive because she felt she fabricated some of the information to the police, or whether she's being evasive because she didn't remember, but she did state that she was intoxicated, or whether she's being evasive because she's protecting the defendant at this point is unclear. And the court believed would reasonably lead to jury questions, and not necessarily something the court believes that they need to address as of today. However, the court is looking at the elements for assault with a dangerous weapon. It says the defendant either attempted to commit a battery or did an act that would cause a reasonable person to fear or apprehend immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, that the defendant intended either to injure, in this case it would be Mariah Maldonado, or to make Mariah Maldonado reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery. So to the prosecution's point, the first element does not require any testimony from Ms. Maldonado that she personally was in fear or immediate battery, but it just requires a reasonable person standard. I would agree that if I'm arguing with someone and they pull out a firearm, whether or not they discharge anything into the air or into the building, that's really not germane. I mean, a reasonable person would apprehend that you're pulling out a firearm to use it in a way to threaten me. So I think that the first element is satisfied. Second, that the defendant intended to either injure the complainant or to make the complainant reasonably fear an immediate battery. Again, although she did not specifically testify that she was in fear of a battery at that point, again, she's being evasive. And then there was even some testimony through 27C from Detective McGonigal about the victim when she was interviewed, discussing two separate incidents. So she even mentioned some of this incident again to Detective McGonigal. But nonetheless, again, I think that it's reasonable that she was placed in fear of an immediate battery when the gun was pulled out and allegedly that there was a discharge of a bullet into the air. So the court believes that the second element is also satisfied. Third, that the defendant had the ability to commit a battery or appeared to have the ability or thought he had the ability. I think based on the testimony and the evidence as presented, that that element is also satisfied. So count 2 as charged will be bound over to the circuit court. Count 3 is felony firearm for possession of a firearm, that being a handgun or could be a rifle based on the testimony of the alleged victim. For the felonious assault, that is satisfied per probable cause standard, that will be bound over to the circuit court. Count 4, felony firearm for the discharge into a building is dismissed for lack of probable cause, and people are requesting to add a count 5 of domestic violence because the testimony does lay out a dating relationship amongst the two at the date and time of the alleged assault. So the domestic violence will be added and bound over to the circuit court on that file. Now taking count of file 26-01637. We had testimony also from Ms. Maldonado about an incident having occurred again in June 19th. So about a month later, still again, the address being the same at her trailer park, which was the location of 3407 West Mount Hope, lot G9, City of Lansing, Indian County, again, making venue appropriate in this court, that she was there with a person that she identified as a Kavaris Brown, and that she had saw the defendant that morning, that they had been arguing via messenger. She said that her door had gotten shot, and she, again, being less than forthcoming, stated she did not recall telling Detective McGonigal that she saw the defendant level a gun to her door. Again, she testifies that on that night she had drank a lot. So again, we don't know if her lack of candor in the courtroom was due to a lack of memory, because she's again just explaining both nights I've drinking a lot, or if she's attempting to cover for the defendant, or if she believes she fabricated the truth at the time. I don't know. It sounds like it's a question for a jury. And so we then heard from a Veda Jo Pratt, and she is a neighboring tenant of this trailer park. She testified that she, on the alleged date of May 18th, heard multiple gunshots next door. She said she thought she heard about 5, and that she heard a door slamming, people screaming, and heard the victim screaming, and at least another voice. And then I think she was specifically asked about whether or not she could be familiar with the victim's voice, so as to identify or ascertain if she could say in any level of certainty whether or not the screaming she heard. She testified that was her neighbor. She knew it was her neighbor screaming on the May 18th day. She also testified that on June 19th, that she heard gunshots and that a bullet went through her window. She was extremely emotional. She said that the bullet came dangerously close to her child's crib, and I think that she had just walked out of that room. She said that she identified the defendant as someone who looked familiar to her. We had testimony then from a Tavares Brown Sr. He stated that on June 18th, he spent the night at Mariah's home. They had been drinking. I think everyone's consistent on that part. And he heard pop, pop. He described 2 distinct pops. He looked at his leg and saw a bullet hole in his jeans. He said he saw the defendant, and then within seconds, he heard those pops. And that Mariah and her friend ran into the room, and then later that one of Mariah Maldonado's friends transported him to the hospital. People admitted exhibits 1, 2, and 3 of photos of the defendant at the hospital. He described again the nature of the relationship between him and Miss Maldonado. It sounded like they were having, again, a relationship, I like the way you termed it, that they were less than proud of, and that he had heard Mariah arguing with someone he identified as Junebug, and that she said Junebug was talking crazy. And it was clarified that Junebug is a name that's associated with the defendant, Mr. Thomas Evans Jr. That after the argument, he heard what he thought to be someone or the defendant leave, but then he saw the defendant walk past the window, and then that's when he heard the two shots. We heard testimony from another neighbor, Gregory Fisher. He testified that he lives in 3407 West Mount Hope, G13, 3 to 4 trailers from the victim. But that on June 19th, he had his door wide open. He was sitting on his couch when he heard 2 gunshots. He said he saw a gentleman walking up the driveway really fast, one of which was shoving something the size of a handgun into his pants. And then he later described a truck swirling away. He specifically said he saw the guy in the driver's seat and described him to be heavyset with a beard. And he pointed and identified the defendant as the person he recalls driving away in the truck at a high rate of speed, and also as the same person who walked by the window. We heard testimony from Officer Summer Haynes. She was on patrol and she arrived with Officer Vanderwerf to the scene of the incident. People's Exhibits 4, 5, 6, and 7 were admitted for her testimony. We then heard from LPD Officer Tisha Applegreen, who was in training at the time. She also responded to the June incident at 3407 West Mount Hope. She described some excited utterances, including some erratic, scared, and scattered thoughts of the parties, the Miss Maldonado to be specific. And she observed a bullet hole or damage to the door, and that she was told that it was caused by Thomas Evans. There was a search warrant of the location executed by Officer Olson, Robert Olson. And then we heard from Officer Peter Howard, or I was told that Officer Peter Howard, that is, responded to Sparrow regarding the shooting of the victim, and the passenger in the truck was uncooperative. They were in a single cab Ford F-150. He said he saw a handgun on the floorboard near the defendant. We then again had testimony from Detective McGonigal. She took or presented testimony under 27C, again, talking about the 2 separate incidents that Ms. Maldonado described to her and narrated, and that she testified that Tavares Brown was laying on the sofa, woke up to seeing the defendant walk outside the home, and defendant shot into the home. Then today we heard the testimony again from Officer Vanderwerf, who also responded to the scene. He also was present during the arrest or the attempt to make a traffic stop on the Ford F-150, which had been described by multiple previous witnesses. I think that he was at the time with Officer Kilborn and Officer Kerrigan, and that they located this vehicle at the area 5913 Waverly, which would be within Ingham County or within 1 mile radius of Ingham County, making venue appropriate in this court. They executed a traffic stop. I think it was executed by Deputy Kerrigan because he was also in a unmarked vehicle, but his had the lights. And so they gave several commands to the defendant. He testified the defendant failed to comply with those commands. It took about 5 minutes before they could even approach and bring the defendants into some sort of compliance. But there were multiple commands for him to exit the vehicle and keep his hands up. But they noticed that the defendant had a glove on his right hand, which he states based on his experience was consistent with someone who possibly would be using a gun so that he could keep his fingerprints off the gun. Although we heard from defense's line of questioning that it could be for baseball or it could be for doing some work. in protecting, in doing that work, he wanted to protect his right hand. And maybe he was doing that work in the vehicle. I don't know what he would be wearing the glove for in the vehicle. Definitely wouldn't be playing baseball in the vehicle at that time. So it's not reasonable to think that he would have the gun on for that. But if there was, he said at the time that they later took him into compliance after having to strike him, it says 4 times, that they did find a black Smith & Wesson 40 caliber handgun in the area at where he was sitting. They did notice his left hand dropping multiple times prior to taking him into custody. And so it's reasonable to think that if he was wearing a gun, that it's probable or more likely, more than mere suspicion, that the gun was being worn because he was handling something in the vehicle and there was no evidence or testimony that a baseball was found in the vehicle or any other tools other than a firearm. Count 1, assault with intent to do murder, as it relates to Tavares Brown. The court is satisfied based on the testimony of both Tavares Brown and the other witnesses that testified, multiple of them identifying the defendant as being the person arguing and then outside the home discharging a firearm. The court is satisfied that this more than mere suspicion of count 1 that will be bound over to the circuit court. Count 2, carrying concealed. The people are requesting to amend that to the Waverly address, which I believe was testified to be in 5913 Waverly. And so that will be amended. And the carrying concealed weapon as it relates to the weapon that black Smith & Wesson that was located near the defendant when he was taken into custody with the 1 glove on. The court is satisfied that there's sufficient probable cause that will be bound over to the circuit court. Count 3, police officer assault resisting obstructing. The people are requesting to amend that to Officer Zachariah Vanderwerf. That's the testimony that we had today, that multiple commands were given and that the defendant failed to comply with those commands. Officers, he was certain even from the beginning that the defendant heard his commands, as he said he could see the defendant responsive with his lips, but they couldn't make out exactly what he was saying. That the defendant had to be struck 4 times in order to get him to comply with the commands and then taken into custody. The court is satisfied as to count 3 that will be bound over to the circuit court. Count 4, weapons, firearm discharged in or at a building. Again, there was testimony that there was 2 shots fired and that one of those shots went through, or I suppose hit the defendant, hit the victim, that is Tavares Brown. The other went through the building into the next building and into the bedroom of another victim's infant. The court is satisfied for count 4 that there's sufficient probable cause for firearm discharge in or at a building that will be bound over. Count 5, assault with intent to murder as to Mariah Maldonado. There again, testimony is that there was a discharge into the home of 2 shots. And this is after the defendant had been, I guess, texting with Miss Maldonado earlier, and she makes the statement that Junebug is acting crazy. And then 2 bullets are discharged into her home. The court is satisfied that there is sufficient probable cause as to count 5, assault with intent to murder for Mariah Maldonado. Count 6, which is felony firearm or to accompany the assault with intent to murder, is satisfied and will be bound over. Count 7, which is another felony firearm that was to accompany the other assault with intent to murder, that will be bound over to the circuit court as well. Then there's a count 8 of weapons, felony firearm. This is for the count 4 of discharge with a building into a building. The court is satisfied that a firearm was used for that purpose, and that there is sufficient probable cause to find that over. Count 9 is malicious destruction of a building. We do not need to address probable cause because it's a misdemeanor. So it will accompany the felonies. The people are requesting count 10. Of another discharge into the building, which would, based on the theory of a transfer intent, there was again, 2 bullets that went, or that were alleged to have been discharged. One of them went into the leg, allegedly, of Mr. Kavaris Brown. The other one entering the first building, then exiting and entering another home. The court again is satisfied as to probable cause that there was a second discharge into a building. And so then added count 10 will be granted and bound over to the circuit court. And then there's a request to add a count 11 and a count 12, a felony firearm. Count 11, a felony firearm to accompany the new discharge into the building. Is that correct?
Yes, Your Honor.
Okay, and then the count 12, you're requesting felony firearm for the police officer assault resisting obstructing. I do agree with the defense. I don't know how the firearm was used in the assault resisting obstructing.
Your Honor, may I?
Yes.
My understanding is that all that's required is possession, that it does not need to be used. That is our theory, that he possessed it, and that's why I went to the instruction, whichever instruction it was. So I went to instruction.
I mean, that is the element. It says he did have or carry in his possession a firearm. That would have been a handgun at the time that he committed or attempted to commit the felony. In this case, it would be police officer assault resisting obstruction. I'll grant the count 12. That is count 12. I'll grant the count 12 of a felony firearm that is for police officer assault resisting obstructing. That will be bound over to the circuit court as well. Lastly, there is a count 13. Domestic violence. It's a misdemeanor. We don't need to address it, but there was a testimony of the dating relationship that will be bound over and accompanying the other felony counts. Bind over dates for each of these files. It's going to be September 2nd. That's the date the circuit court receives the files. Not a court date for you, Mr. Evans. Your next court date will be a pre-trial in circuit court, and your attorney will be made aware that he'll remain in contact with you. Do you have any questions for the court at this time?
No.
It looks like bond was 350,000 cash shorty on a file number ending in 37. Actually, in both files. That will continue with GPS study and victim notification if possible. Any additional matters for the record?
I think I'm
Yeah.
happy. Go ahead, sir.
Sorry, I do want to clarify, I was looking at the complaint and there are just some location errors I would like to have pressed on the information. We already addressed count 2. Every single count, it indicates G13. I'm not sure where exactly that came from. I would request that counts 2, 3.
I'm sorry. You're talking about,
G9, Russ.
that says G9 on mine.
Either way, I don't know why I wrote 13. Oh, G9. My recollection is that Miss Maldonado resided at A19 and that Miss Pratt resided at A20.
Yeah, but it sounds like you gotta follow them in the complaint too, anyways, because there's a lot of changes, so you're gonna have to follow them in the complaint.
Would there be any objection to just correcting it? Because then there are some that were charged as the G9 that should have been the 5913 South Waverly.
Okay, I do know that the 59, I mean,
Then the count 3 R&O
Count
was charged
3.
G9 that happened at the 5913 South Waverly.
which I addressed on the record.
Yeah.
That should be 5913 South Waverly. And then
And the G9 should be A19. I don't know where G9 came.
Yeah, I don't know if I did this right. Let's see.
And then just to clarify, the added discharge at a building and the accompanying felony firearm, that would be A20.
Oh, it would be, I guess, count 2 and 3 should be 5913. No? Wait.
Yes, both 2
And
and
the count
3,
12.
and then also count 12.
And then I don't know if G9 is supposed to be on any of them. Is that what you're saying?
G9, I don't know where G9 came from.
I don't either.
I don't either, Judge. I do think if the address needs to be fixed, I don't see an issue with the objection on
So
that.
the record, yeah, I definitely have A19 on that. Oh, that was for, yeah, because Ms. Pratt lives at A20. Is that correct?
Yes,
Yeah.
and then Mr. Fisher was at G13, which is where.
Yeah, I don't know where these
G9
numbers came from, but we'll just note for the record, because it is a lot, that there will be an amended complaint filed with the corrected addresses that were elicited during the testimony.
But
No worries. Any additional matters?
nothing about Mr. Jones.
I just would request a transcript from the prelim for that. I always forget to request, we would like transcript.
You gotta sign the form.
Yep, there's just a form over here for you to complete, and you're all set.
That's the serious one. So I think,
Yeah.
Is it broken?
I don't know if I'd say broken, it's not, it's a
It's
little
been a
wobbly.
little screwy for a long
It's
time.
not stable? Yeah,
Yeah.
you're right. I mean,
It fits in with the building.
well, yeah, it's the one next to Ross.
Oh,
Let me just sign that, I'm gonna fill it out. You could put the name on there, though.
Yeah. We need to do one for both dockets or just one? for
No,
I think one transcript is. I mean, you see the different colored font depending on which.
Yeah,
file
that's
testimony.
but you know you do. You do.
there's some other ones that I don't have your signature.
Look at the glasses, okay? We're sitting back here. Okay, in the car.
Just,
Just give it. Yep.
all right, thank you.
Thank you. For the next hour, getting all the addresses right.
No, literally, my note here is like, I'm not right now.